Gary DeWaal here, and this is Bridging the Week for August 10th to 14th, and today is August 17th, 2015. Good morning. Enforcement actions, both in the UK and US, dominated the most notable developments regarding financial services firms last week. In the US, a network of 32 persons were charged civilly by the SEC, and some defendants were also criminally indicted by the US Department of Justice for hacking into newswires and trading on non-public information prior to the information's scheduled public distribution. In the UK, 5 defendants were fined the equivalent of almost $12 million for layering type activity, while in the US, an administrative law judge upheld FERC charges that BP Group companies manipulated natural gas prices in Houston, Texas to benefit their trading position following a hurricane in 2008. We have a lot to cover this week, so let's get started. The computer servers of 3 major newswire companies were allegedly hacked as part of an elaborate illicit stock trading scheme that resulted in civil charges being filed last week by the Securities and Exchange Commission against 32 defendants. 9 of these persons were also subject to criminal indictments filed in Brooklyn, New York, and Newark, New Jersey by the U.S. Department of Justice. According to the SEC and the DOJ, 2 individuals from the Ukraine masterminded the scheme by hacking into the newswire company servers from 2010 through 2015 to steal press releases regarding publicly traded companies before they were made public. Many of these stolen releases contained quarterly and annual earning information. The hackers stole more than 150,000 press releases, claimed the DOJ. The 2 hackers worked with a network of traders in the US and abroad who paid the hackers for the stolen information in return for a flat fee or percentage of any trading profits. The SEC said the defendants generated over $100 million in profits trading on the illicit information. The SEC seeks an injunction and asset freeze against the defendants, as well as damages and disgorgement. The DOJ also seeks penalties from and imprisonment for each defendant. The UK High Court imposed a permanent injunction and penalties of over 7.5 million Great British pounds, or approximately $11.8 million, against 5 defendants for engaging in market abuse in an action brought by the UK Financial Conduct Authority. The FCA charged that between August and December 2010 and from February until July 2011, the defendants engaged in layering-type conduct related to shares of stock traded on the electronic trading platform of the London Stock Exchange and multilateral trading facilities. The UK High Court hears civil cases and consists of 3 divisions: the Queen's Bench, the Chancery, and the Family Divisions. Appeals from the High Court are made to the UK Court of Appeals and to the UK Supreme Court. ITG Inc. and Alternate Securities, its affiliate, agreed to pay $20.3 million in sanctions to resolve allegations by the Securities and Exchange Commission that ITG impermissibly used confidential trading information in connection with the operation of its dark pool known as POSIT. According to the SEC, on multiple occasions between April 2010 and July 2011, ITG routed sell-side customer trades without their knowledge to POSIT, against which ITG's proprietary trading desk, known as Project Omega, traded. Typically, Project Omega's trading algorithm would detect that a client wanted to buy or sell a stock, and then would first buy or sell the same stock for ITG at the prevailing best bid or offer price. The algorithm would then immediately place the client's order for the same stock into POSIT, such that ITG would sell to the customer at the best offer price when the client wanted to buy, or buy from the customer at the best offer price when the customer wanted to sell. This would guarantee that ITG would always obtain the spread between the best bid and best offer on all such transactions. However, during the relevant time, ITG promoted itself and POSIT as an independent agency-only broker that did not have conflicts of interest with its customers and that protected the confidentiality of its customers' trade information. As a result of its trading activity against sell-side customers and other proprietary trading activities, ITG realized gross revenues in excess of US $2 million during the relevant time. To resolve this matter, ITG admitted to the facts charged by the SEC, in addition to agreeing to pay a penalty of $18 million, disgorgement to customers of over $2 million, and prejudgment interest. And administrative law judge last week upheld charges by the Federal Energy Regulatory Commission, initially brought in August 2013, that 4 BP Group entities manipulated the price of natural gas in the Houston, Texas area from September 18 through November 30th, 2008. FERC enforcement staff had charged that the 4 entities engaged in manipulative conduct to benefit a pre-existing spread position involving short index exposure to the price of natural gas at the Houston Ship Channel and long index exposure to the price of natural gas at the Henry Hub facility in southern Louisiana near its Gulf Coast. The ALJ indicated that under applicable statute, BP could be liable for a penalty of up to $48 million and disgorgement of profits for its conduct. The actual penalty to be paid by BP will be decided by FERC at a later time. In 2007, BP Products North America settled with the Commodity Futures Trading Commission and the U.S. Department of Justice related to allegations the firm manipulated and attempted to manipulate the price of propane deliverable in Texas in 2004, among other matters. The European Securities and Markets Authority published 4 reports assessing how the European Markets Infrastructure Regulation framework has been operating and providing recommendations to the European Commission for enhancements. Among other recommendations, ESMA suggests that the process for determining clearing obligations should be streamlined and that a mechanism must be implemented to prevent the suspension of clearing obligations if certain market conditions arise, for example, a clearinghouse fails to operate or one or more clearing members default. And finally, the CME Group settled 2 disciplinary actions for position limit violations by ordering payment of a fine and disgorgement. In one action against William Cruz, the respondent agreed to pay a fine of $25,000 and disgorge profits of almost $40,000 for initially violating the spot position limit in feeder cattle futures contracts on August 22, 2014, and inadvertently increasing the position the next business day. He realized his mistake and liquidated his position on that next day, August 25th. Similarly, Joshua Curley agreed to pay a fine of $20,000 and disgorge profits of almost $4,500 for violating spot month position limits in corn futures contracts on November 30th, 2012, although he liquidated sufficient positions to come into compliance with the position limits on the same business day. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and ciao!